I'm going to do, I'll start with my takeaways.
Mm-hmm.
So we've been at MCLE for those is now, they do a little promo for their YouTube versions of this, where we give you our takeaways for what you should remember after this. So this is what, and they put it at the end so they don't have to watch the whole tape. So this is what you should remember from my talk, from my very quick wander through the wonderful world of data. And that is that data is very valuable. I'm seeing a lot of data plays come across my desk. I'm seeing a lot of clients find value in their data that they never thought they would find in their data. But it is not classic copyrightable software IP. As much as you want it to be, it isn't. It can be treated that way with just a little bit of thought, and you can use torts like trespass to protect it. You can use the selection and arrangement of your data to protect it. You can use the right trade secret processes and procedures to protect it. But you need to be thinking about those things and some of the unique characteristics of what data is if you're going to make money with it. And of course, for personally protectable personal privacy information, PPI. Or PPI for personal information or personally protectable information, you need to comply with the law. And the laws are changing and they're getting more aggressive. And in 323 days from now, we're going to have a version of the California Consumer Privacy Act come online, which is going to give United States residents, or at least the residents of California, who's a pretty big market in dealing with most of our software clients, rights to be forgotten, rights to find out who their data is being sold to, and other rights that if you or your client skipped out on GDPR compliance in the last year, you're probably going to have to do a fire drill somewhat akin to what a good half or third of the software industry went through in any event to be GDPR compliant.
For my key takeaways, I would say first, open source exists and your clients are using it, and that's okay. Don't panic. It's worth, if you're going to be advising them on open source matters, it's worth taking some time to sit down and read and learn about some of the most commonly used licenses. Just get familiar with them, get familiar with what the kind of broad categories that you would put them in are in terms of how to comply with them. Keep in mind, I would say that complying with licenses is more than just a legal solution. It's something that if a company or any organization decides that they're going to take seriously their obligations to comply with open source licenses, that's not something that just the legal team can do, that it really requires cross-functional coordination between typically the legal team, the developers, and the management of the company. And then finally, I'd say that open source license management is not and should not be viewed just as a risk management consideration, that it's worth, particularly for tech-focused companies who are looking to interact with communities and looking to hire developers who care deeply about what they're doing and about their work, that your perception in the community of participating in open source communities, of contributing, of following the rules, all of that matters, and it's worth viewing that not just through the lens of let's avoid any possible legal risk, but also let's just do the right thing when it comes to making use of this.
My key takeaways, I guess, are one, when you're dealing with royalty provisions, get an accountant to work with you on them. I've seen people get tripped up on this so many times. I cannot stress it enough. If you can't figure out how to calculate, and pay your royalties correctly, you're going to end up in a messy lawsuit. Think in advance about your backup positions for clauses that you see getting negotiated over and over again. I didn't talk about this in my talk, but we did an exercise a few years ago where we went through the 9 most negotiated clauses, and we came up with second position, third position, fourth position. So when a customer would push back on us, we would just send them our next, most preferred clause instead of working with their language. It kept the power in our court. And it's not just about legal. do your due diligence on the companies that you're doing business with to make sure that they can stand behind the promises that they're making on paper. You can, David said this too, you can write the best limitation of liability or indemnification clause or warranty ever. If the company can't comply with it, they're going to go out of business and you're going to be left holding the liability. So, you know, think about the practical aspects of the license as well as the legal ones.
And to that, and to follow on with that, the takeaway from that last final panel, I think is and has always been intended to be, it is a small community, and we are, unlike a lot of lawyers, we're about building business relationships. We are, ideally, we're entering into software relationships, and not, you know, I might be more of the bad cop in a scenario than my client is, but ultimately, I'm not a divorce lawyer, I'm a marriage lawyer, bad example. But it's about finding ways that the clients can work together, finding ways that you can have a win-win relationship. To Steve's point about ambiguity, it's about making sure that they understand each other. To me, oftentimes I'll be like, I'm going to ask a tough question just because I want to make sure that you're both on the same page, right? And that really is the most important skill here. It's not getting the best limitation of liability. It's making sure you have clients that aren't ever going to need it, right? And so with that, I would like to thank you all for taking the time to be with us on this snowy Tuesday afternoon and release you out to Boston commuting chaos.
Thank you.